Hello viewers, welcome to today's session of Nigerian Law Documentary. On today's session, we'll be looking at a very interesting topic, co-ownership of property. Does the law allow two or more persons to have title over a particular property? The purpose of this discussion shall be focusing our attention on landed property. Is it possible for two or more persons to have title to a particular property? Well, the answer to this question is a categorical yes. Yes, the law allows more than one person to assert title or to have concurrent title over a particular piece of land or over a particular property, any property at all. So, what happens in situation where more than one person own a property? The Supreme Court, in the case of Shoniku and Smith, decided that it's possible for more than one person to have title to a particular property. And when more than one person own a property, there are four characteristics that those persons enjoy. The first is that they enjoy unity of title. All the co-owners enjoy unity of title. The second is that they enjoy unity of possession. The third is that they enjoy unity of interest. And the fourth unity they enjoy is unity of time. So we have unity of time, unity of title, unity of interest, and unity of possession. So all these unities, the co-owners enjoy these four unities concurrently. Each co-owner has title, has possession, has interest in that property concurrently with other co-tenants. So I may be using the word co-tenants. It doesn't necessarily mean the owners are co-tenants. That's just the legal term for co-ownership. Furthermore, in the case of Kuri and Kuri, the court highlighted some of the incidents of co-ownership. An action for trespass does not lie in favor of any of the co-tenants against the other. And also, all the co-tenants, all the joint tenants have equal and undivided control over the whole property. So we'll now be moving to the types of co-ownership. Generally, there are two types of co-ownership known to law. The first is joint tenancy and the second is tenancy in common. So these are the two types of co-ownership that the law permits. And each of these co-ownership has its own unique incidents that follows. So let us start with the first one, which is joint tenancy. The In joint tenancy, the idea of the four unities applies rigidly in joint tenancy. The unity of time, unity of title, unity of interest, and unity of possession applies rigidly. And this is the position of the Supreme Court in the case of Shoniku and Smith. Furthermore, another incident that is very unique to joint tenancy is the incident of survivorship, the incidence of use accrescendi, and this incident was correctly applied in the case of Chinweze and Mercy. In this instant case, the mother on her first marriage became pregnant, and after she was pregnant, her husband died and she gave birth. And after she gave birth to her daughter called Veronica, and the estate, her late husband estate, passed to both the mother and the daughter, and they were holding the same estate concurrently as co-tenant with her daughter. She subsequently got married to another man, and she also gave birth to some children in the second marriage. Upon the mother's death, Veronica, the child of the first marriage, sold the property. She sold the property that was jointly owned with her mother. The children of the second marriage challenged the said sale, saying that they grew up living in that same property and they were also entitled to that same property. They were entitled to a share in that property. The Supreme Court, in deciding this matter, decided it on two grounds. The first was on the ground of legitimacy, which is that the children of the second marriage were not even children in respect of the first marriage, so they are not even entitled to inherit the first husband. He's not their father, so as to entitle them to inherit his property. The second ground was on the basis of joint tenancy. The court vehemently held that Mrs. Elizabeth and her daughter Veronica were joint tenants in the sense that they hold the property concurrently. Their interest is one, and there is no word in their title document that sever their ownership of that property, that entitle each one to a separate share. They hold the property concurrently, jointly, and the incidence of the four unities is present, and as such, Mrs. Elizabeth only has a life interest. Upon her death, her own share does not pass to her other children. It passes to the other co-owner, which is Veronica. And Veronica is the only surviving joint tenant. And as such, upon the death of her mother, both her mother's share and her own share passes to her. She becomes a sole owner, which brings an end to the co-ownership. The interest of a joint tenant, the interest of a co-owner does not pass to his heir. It passes to the other co-owners. So imagine if I am a co-owner with my friend with respect to a particular piece of land, and there is no word of severance that say I have a separate share. Upon my death, it is not my children that will inherit me. It is that other person that I am co-owner with that will inherit my own share, because the property is concurrently held during the lifetime of the co-tenant, and there is no word of severance, and the four unities is present in that kind of ownership. So it was the position of the court in the case of Chinweze and Mercy that each co-owner's share will continue to extinguish until there is only one survivor left, and that last survivor will lay claim to the entire property. So the second type of co-ownership is the tenancy in common. In tenancy in common, it's a kind of co-ownership where there are ways of severance. Mr. A will have 5% of the property, or Mr. A will have half of the property, and Mr. B will have half of the property. In such situations, each co-owner is entitled to a specific piece of the property such that he can lay claim to the property, and as such, that property upon his death passes to his heirs. It passes to his heirs, and the other co-tenant cannot lay claim to the said share of the deceased. Or if it is in a will, where a father makes a will for the distribution of property among his children, then and he specifically mentioned each share that each child shall have. So those children cannot be said to be co-owners, because there is a distinct share that each child shall have, and it is the intention of the donor that the donees shall have a separate and distinct share from the whole property. So in summary, basically there are two types of co-ownership: joint tenant and tenancy in common. Joint tenant is a form of tenancy where the share of a deceased, or the share of a co-owner does not pass to his heir, it passes to the co-owners, while tenancy in common is a kind of tenancy, or is a kind of co-ownership where there is a particular share, where each co-owner is entitled to a particular share, and his own part of the property passes to his heirs. His heirs are entitled to inherit him upon his death. And the distinction between these two types of co-ownership obvious from obvious from what I have said earlier. The principle of four unities is present in joint tenancy. Meanwhile, in tenancy in common, it is not present. It does not exist, because each co-owner has a distinct share. And the principle of survivorship, the principle of jus accrescendi, applies rigidly in joint tenancy. However, this principle is unknown to tenancy in common, in the sense that the share of a co-owner passes to his heirs, not the other co-tenants. So that is that about co-ownership and types of co-ownership. However, there are other forms of co-ownership that may exist in law, like ownership between husband and wife. This is an interesting area of law that we'll be looking at in our next video. So anticipate. And another topic that we'll be discussing in our next video will also be sale by a co-owner without the consent of the others. Is that sale valid? Does he have right to sell the entire property, which of course he is not entitled to? So anticipate that too. Thank you for watching this interesting video. Don't forget to always like our videos. It's very important that you like our videos so that we know that we are doing a great job and will continue doing. Always comment. Go to the comment box. Let us know how you feel about this video and how it has been helpful to you. And also share our videos. Share our videos with your friends and family. And don't forget to follow us on our Facebook page, Nigerian Law Documentary, and subscribe to our YouTube channel. It is very important. Please do that for us. Thank you.